My father didn't just say it, he screamed it. At 10:47 a.m., in a packed courtroom, Douglas Merritt pointed a shaking finger at me and told the world, "She is an embarrassment to this family. She has never been anything but a disappointment." The room went dead silent. The lawyers froze. My father thought he was finally destroying my reputation. But then, Judge Catherine Reyes leaned forward. She looked at the legal documents on her desk, then looked at my father's arrogant face, and asked a single question that turned his world upside down. She didn't ask about my embarrassing past. She asked him about the $5 million trust fund he had been illegally draining in my name for 20 years. Before I tell you his reaction, you need to see how I caught him. My name is Serena Merritt. I am 34 years old. I am a civil rights attorney at a nonprofit legal organization in Philadelphia. I have spent the last 7 years representing clients whose voices are not heard in rooms where decisions are made about their lives. I have won cases that established precedent. I have stood in courtrooms significantly more imposing than the one I am describing and argued positions that required complete command of fact and law and the particular composure that comes from believing entirely in what you are doing. I am, by any professional measure, successful at my work. My father does not consider my work meaningful. Douglas Merritt spent 35 years as a senior partner at a corporate litigation firm. The kind of firm that represents corporations in disputes worth hundreds of millions of dollars. The kind of practice where success is measured in billable hours and settlement figures and the names of the clients whose problems you have made disappear. He had wanted me to follow him there, to take the path he had cleared, to use his connections and his name and his network to enter the world he had built and occupy a place in it that would reflect well on him. I had chosen a different path, deliberately, completely, with full understanding of what the choice would cost me in his regard. I had known since law school that I wanted to work in civil rights, had clerked for a federal judge whose docket was full of cases that involved real people and real harm and real consequences, had joined the nonprofit sector straight out of the clerkship despite 3 corporate offers that would have paid 3 times as much and made Douglas briefly, conditionally proud. He had not spoken to me for 4 months after I took the nonprofit job. When we resumed contact, it was with the particular distance of a man who has decided that his child's choices are a judgment on him and has chosen resentment over understanding. Every family gathering became a performance of that resentment, subtle at first. Questions about when I was going to do something serious with my degree. Comments about whether my clients could afford to pay me properly. Observations about the salary differential between public interest law and corporate practice, delivered in the tone of someone pointing out a math error. Then, less subtle, comparisons to my cousin Derek, who had joined a corporate firm and was making partner and driving a car Douglas approved of. Introductions at family events that described my work in ways designed to minimize it. A particular expression when I spoke about a case I was proud of that communicated, without language, that proud was not the right response. My mother, Eleanor, navigated between us with the exhausted grace of a woman who had been managing her husband's ego for 36 years. She loved me. She also would not contradict Douglas directly, which meant her love arrived quietly and sideways and was real, but never loud enough to matter when it needed to be loud. My younger brother Patrick worked at Douglas's firm, had made the expected choice and received the expected rewards. He was not unkind to me. He was simply comfortable in the approval that I had forfeited, and comfort does not usually make people generous toward those who remind them of what they have traded for it. The court date had been set for a Tuesday in March, a family matter. The kind that happens when a parent dies and leaves behind an estate that has been arranged and rearranged over decades in ways that not everyone understands until the documents are read aloud by a stranger in a formal setting. My grandmother on my father's side, Ruth Merritt, had died in November. She was 84, sharp until the last year. A woman who had run a small business for 40 years and understood money and independence and the particular clarity that comes from building something with your own hands. Ruth and I had been close, closer than Douglas knew, or closer than he had paid attention to. She had come to my law school graduation and sat in the front row and wept when I was hooded and told me afterward that my mother would have been proud, by which she meant her own mother, my great-grandmother, who had wanted to be a lawyer in a time when that was not possible for women who looked like her. Ruth had updated her will 18 months before she died. I did not know the contents until the attorney read them. The estate was to be divided equally among her 3 grandchildren, me, Patrick, and my cousin Derek equal. Not apportioned by career success or income, or the degree to which each grandchild had made Douglas Merritt proud at family dinners equal. Douglas had contested it. Not the amount itself, the amendment. Ruth had updated her will to include a specific provision, a personal bequest, that was directed to me alone. A letter she had written, a collection of her professional journals from 40 years of running her business, a particular piece of jewelry that had belonged to my great-grandmother, and a note attached to the bequest that the attorney had been instructed to read aloud in the proceeding. Douglas had contested the validity of the amendment, had hired a colleague to argue that Ruth had lacked capacity at the time of the update, that someone had unduly influenced her, that the amendment should be set aside. The capacity argument was, in the opinion of Ruth's own attorney and 2 physicians who had documented her mental acuity within 6 months of the amendment, without merit. The undue influence argument was thinner still. But Douglas had resources and connections and the particular tenacity of a man who cannot accept a verdict he did not arrange. We were in court because he had insisted on being in court. I had not wanted to be here. Had told my own attorney, a quietly brilliant woman named Frances who had handled estate matters for 20 years and who had reviewed the case and said the word meritless twice in our first consultation, that I would prefer to resolve this without litigation. Frances had said that Douglas did not want resolution. He wanted control, and that the only way to address that was to let the court address it. So we were here. The proceeding had been underway for an hour and 40 minutes when Douglas requested to make a statement. His attorney looked briefly uncomfortable, which is the expression of an attorney who has advised their client against something and been overruled. The judge had allowed it, granted Douglas 5 minutes. He had used 2 of those minutes to argue again that his mother had been manipulated, that the amendment was the product of a campaign to undermine the family's wishes, that I had cultivated a relationship with Ruth for exactly this purpose. I sat at the table beside Frances and kept my hands flat on the surface in front of me and kept my face still and did not look at him. Then he had said what he said. She is an embarrassment to this family. Everything she has done has been an embarrassment. She has never been anything but a disappointment and an embarrassment, and I want that on the record. The silence after it was complete, and Judge Catherine Reyes leaned forward, looked at my father over her reading glasses, and asked, "Mr. Merritt, can you tell me specifically what your daughter has done that you consider an embarrassment?" My father blinked. He had not expected the question. He had expected the statement to land as a statement lands, weightily and finally, and for the proceeding to continue with the understanding that it had been heard and registered. He had not expected to be asked to support it. "She has wasted her education," he said. "She went to a top 3 law school and she works for a nonprofit that pays her a fraction of what she is worth." "She is a licensed attorney in good standing?" the judge asked. "Yes, but she practices law professionally?" "In a manner of speaking, Mr. Merritt," the judge's voice was not unkind. It was the voice of someone with very little patience for imprecision who is choosing to be precise in the face of it. "I am going to ask you to be specific. You have described your daughter as an embarrassment and a disappointment. I would like to understand the factual basis for those characterizations." Douglas shifted. His attorney was very still. "She has chosen a path that does not reflect well on the family." "How so?" "She works in public interest law, for very little money, when she had opportunities to do serious work. Is public interest law not serious work?" A pause. "It is not what I had in mind for her." "I see." The judge made a note, looked up again. "Mr. Merritt, I am going to ask you to direct your attention to the matter at hand, which is the validity of your mother's testamentary amendment, and to set aside characterizations of your daughter's professional choices, which are not relevant to the legal question before this court." She looked at me then, for a moment, the kind of look that communicates something without language. Then she looked back at the documents in front of her. Frances leaned slightly toward me, wrote 2 words on the notepad between us. "We're fine." She was right. The proceeding concluded 40 minutes later. Judge Reyes found that the amendment to Ruth's will was valid, that the documentation of Ruth's mental capacity at the time of the update was thorough and credible, that there was no evidentiary support for the claim of undue influence, that the bequest stood, the journals, the jewelry, the letter, all of it mine. Douglas did not look at me when the ruling was delivered. His attorney gathered papers with the quiet efficiency of someone managing a loss that had been predictable. Patrick, who had been seated in the gallery, stared at the ceiling. My mother was not there. She had not come. I did not know whether Douglas had told her not to or whether she had chosen on her own not to witness whatever this day was going to be. Either way, the absence was its own information. I thanked Frances in the corridor afterward. She said it had been straightforward and that she was glad it was done. I walked to my car, sat in the driver's seat for a long time without starting the engine. Let myself feel the things I had been holding carefully in check for the past 2 hours. The grief of being called an embarrassment by your father in a room full of strangers. The particular exhaustion of having been dismissed by someone whose opinion you stopped needing years ago but whose words still find the places in you where the need used to live. I let myself feel it, all of it, for approximately 8 minutes. Then I started the car and drove to my office. I had a client meeting at 2, a family who had been waiting 3 months for a hearing, people whose case mattered enormously to them and to the legal question it raised, people who needed me to be present and focused and fully in the room with them. I was present, focused, fully in the room. That was who I was, had always been, regardless of what Douglas Merritt wanted on the record. Ruth's letter arrived with the rest of the bequest 2 weeks after the ruling. Frances delivered it personally, set the sealed envelope on my desk with the journals and the small velvet box containing my great-grandmother's brooch. I opened the letter alone that evening. Ruth's handwriting was clear and angular, the handwriting of someone who had written checks and contracts and business correspondence for 40 years and had never been sloppy about it. The letter was 4 pages long. She wrote about the business, about what it had taken to build it in an era when the things stacked against her had been significant and she had not been given the option of considering them insurmountable. She wrote about my great-grandmother, who had wanted to argue cases in a courthouse and had argued them instead in every room she entered for 82 years. She wrote about watching me grow up in a house that did not always make room for what I was. She wrote, I have watched your father confuse his preferences with your obligations for your entire life. I want you to know that I have never confused them. You became exactly who you were supposed to become. The fact that it did not look like what he planned does not diminish it. It confirms it. She wrote, the brooch belonged to your great-grandmother. She wore it on the day she argued her first case before a city council that had never heard a woman speak with authority in that room. She wore it and she was not embarrassed. I want you to have it for the same reason. I read the letter 3 times, set it down, looked at the brooch in its velvet box. It was small, silver, a simple design that had been worn so often the edges were softened with use. The kind of object that carries weight not because of what it is made of, but because of what it has been present for. I put it on, went to the mirror in my office bathroom and looked at it against my blouse, at the object that had been in a courthouse before I was, that had been worn by a woman who was told, in one way or another, that she was too much or too little, or not the right kind, or not what anyone had in mind, and who had walked in anyway, spoken anyway, been exactly who she was anyway. My father had asked the court to put it on the record that I was an embarrassment. The judge had asked him to support the claim. He had not been able to. That was the record. That was what stood. I wore the brooch to court 2 weeks later. My own case. A plaintiff I had been representing for 18 months. A matter that had required everything I had in terms of skill and patience and the particular willingness to keep going when the institutional weight pushing back against you is enormous. We won. Not a small win. A precedent-setting one. The kind that other attorneys in my field cite in their briefs. The kind that changes what is possible for people whose voices had not, until that ruling, been given adequate weight in the rooms where decisions were made about their lives. I stood on the courthouse steps afterward and called my client and told them, listen to the sound on the other end of the phone, the particular sound of someone understanding that they have been heard, that the system has, this time, seen them. I thought about Ruth, about the letter, about my great-grandmother and what she had argued in a room that had never heard her kind of voice before and had not been ready for it, and had been changed by it anyway. I touched the brooch. Douglas did not call after the estate ruling, did not reach out in the weeks that followed. Neither did Patrick. My mother called once briefly, said she was sorry things had gone the way they had, which was the closest she would come to naming what had happened in that courtroom. I said I was fine. She said she knew. We talked for 6 minutes about nothing consequential and said goodbye with the particular warmth of 2 people who love each other and exist on opposite sides of a choice that cannot be made. I thought about whether to reach out to Douglas, whether the courtroom had changed anything, Whether the judge's question had introduced some accountability that he had not been prepared for and that had lodged in him somewhere and might, given time, become something. I thought about it for 3 days. Then I decided that the answer did not matter enough to pursue. Not because I had stopped caring, but because I had stopped needing the resolution to come from him. I had Ruth's letter. I had the brooch. I had the record, which showed that when asked to support his characterization of me, he had offered only that I had not become what he wanted. That was not an embarrassment. That was a life, mine, built exactly as I had chosen to build it. I had stood in a courtroom and said nothing while my father screamed that I was an embarrassment. And the judge had asked the question I had spent 34 years waiting for someone with authority to ask. She had asked him to prove it. He could not. That was enough. That was more than enough. I kept doing the work, kept winning cases and losing some and learning from both, kept standing in rooms where the institutional weight pushed back and pushing anyway, kept being the attorney my great-grandmother could not be in her time and had passed forward through Ruth to me. I wore the brooch on the important days, the hearing days, the verdict days, the days when I needed to remember that the women before me had walked into rooms that were not ready for them and had changed the rooms anyway. It was small and silver and worn soft at the edges. And absolutely the most important thing I owned. My father wanted it on the record that I was an embarrassment. It is on the record that he was asked to explain why and could not. That is the record I carry. Here is what I want to know. If your father stood up in a courtroom and called you an embarrassment in front of a judge and attorneys and strangers, would you have kept your composure the way I did, or would you have spoken back? Some people say there are moments when silence is its own kind of strength. Others say that some things deserve an answer in the room where they are said. Do you think I was right to let the judge ask the question for me, or should I have addressed my father directly? And the question that stays with me, if someone you love cannot see what you have built, does their blindness diminish what you built at all? Tell me your honest answer in the comments. If you believe people should face the consequences of their actions, hit subscribe. I have got more stories of justice that will blow your mind.